right, welcome everybody.
Good morning.
We are just going to take a moment before we get started just to give a couple of other people an opportunity to join us. So just sit tight for a few moments. And if you are not muted, if you could just take a moment to go ahead and mute yourselves, just so we can cut down on the background noise, that would be great. And then we'll go ahead and get started, like I said, in just a minute. Okay. I think we've got a pretty good number of people here. I think maybe just a few more seconds and then we'll go ahead and get started. Okay. Well, it is now 2 minutes past the hour, so I'm going to go ahead and get us going. Good morning, everyone. Thank you for joining us for our training today on working with clients with criminal histories. The next slide is going to provide us with some information about Zoom basics. Of course, I'm sure a lot of you are more familiar with Zoom than you ever hoped to be, ever wanted to be in your lives. But we just wanted to provide this overview in case there are some folks who are relatively new to Zoom. So you're all muted at this time, hopefully, and we ask that you remain muted unless you're coming off mute to ask a question, just to cut down on the background noise during the training. If you have questions or comments during the training, which we hope that you will, please use the chat box to send them out, or there will be opportunities for you to come off mute and ask questions or make comments as well in that way. And we'll be monitoring the chat box throughout and might be answering questions sort of as we go, or we might wait until the end to answer some questions, but hopefully we'll be able to get a chance to answer all of your questions. Worst case scenario, we'll answer them by sending out an email after the training. The other thing is we would really love to see your faces. I'm sure you would all love to see each other's faces. It sort of makes it feel a little bit more like we're all in the same room together. Of course, we understand if you're not in a space today where you want to be on video, that's fine too. But to the extent that you're comfortable being on camera, we would appreciate seeing your faces. So if you all want to just take a moment as well to put in chat your name, the organization that you work for or that you're affiliated with, if you have one. And also, if you'd like to add what brought you to this training today, we love to sort of hear a little bit more about why people are interested in this topic. You know, what brought you here. It always helps us sort of get a sense of where people's interests lie, so we can tailor future trainings better as well. And the last thing I just wanted to say about Zoom is that we are recording this training. So you will receive a copy of the recording or a link to a copy of the recording so that you can refer back to the recording and the training as you wish. And also you'll receive this copy of the slides as well. And we hope that you also feel free to share that information, the recording and the materials with your colleagues as well. Okay, next slide, please. All right, a little bit about Homebase. So today you're going to be hearing from myself, Lila Lindner, and Lily Harvey with tech backup from our wonderful colleague, Nicole Thomas. We are from Homebase, which is a nonprofit organization that provides technical assistance and training to housing and homeless service providers in Santa Clara County. And we wanted to give a quick heads up that although we are going to be talking about legal issues and talking about guidance that exists in various regulations, the content of this training is for informational purposes only It does not constitute legal advice. We're not giving out legal advice to anybody today. If you have legal questions or concerns, we recommend that you reach out to your agency's legal counsel for further guidance. Okay, so just an additional heads up for those of you who might be interested that within the last year or so, Homebase created the Criminal Legal System Initiative, which provides specialized technical assistance and training on issues at the intersection of housing and homelessness or housing instability in the criminal legal system. And it was really born out of, in response to the fact that a lot of our clients, a lot of communities were sort of struggling to meet the housing needs of people who have been involved with the criminal legal system, because some of the unique barriers and issues that they face, are really, really hard to address and overcome. So our hope is that through the initiative, we'll be able to try to move some of these issues forward and create better housing access for folks at this intersection. And we are going to drop a link in the chat later towards the end of the training for those of you who are interested in joining our listserv. Our listserv comes out our mailing list. We send out emails quarterly with additional tools and information and resources sort of about this issue, and we'd love to have you join us for that. All right, so moving on to our goals for today. So we have 4 main goals for today's training, which are for everyone here to understand the intersectional nature of housing, homelessness, race, and the criminal legal system, to identify what criminal histories can and can't tell you about your clients, to learn new ways to recognize and minimize barriers to housing for clients with past convictions, and to explore specific considerations for people on the 290 sex offense registry. And in general, while today's training is not going to provide you with all of the solutions, right, to address this very complex and huge sort of systemic societal issue, we hope that it does help you better understand the issues at this intersection, and also gives you some tools to help you have some of these very important discussions about how to increase access to people with criminal legal system involvement, both within your own organizations and sort of outside in your work with landlords and property managers as well. All right, and then on the next slide, we're going to just go over our agenda briefly. So we're going to start by answering the question, why talk about criminal histories? Then we're going to go over some of the limitations on how we can and can't use criminal history information in making decisions around housing. Then we're going to shift our focus to special considerations for working people on the 290 sex offense registry. And then we're going to round it out with some practical considerations and tips and have some additional time for Q&A to address any of those outstanding questions. Okay, so diving right in. Why are we talking about criminal histories? Why should we talk about criminal histories? So there are 3 major reasons that we're going to talk about today. The first one is that they matter when we consider broader equity issues. The second is that criminal histories can create barriers to finding and sustaining suitable housing. And the third one is that understanding people's criminal histories can help us serve them better. All right, so focusing on reason 1 for a moment. Criminal histories matter when we consider equity issues. This is because, as we know, our country has a very long history of racist housing and policing policies that have, led to, some of the discriminatory issues and impacts that we've seen today. And therefore, certain groups are disproportionately incarcerated and experience homelessness. And this is true at the national, state, and local level. So on the next slide, focusing on the national level. So we know that on a national level, people who have been incarcerated are 10 times more likely to experience homelessness than the general population. And that Black, Indigenous, and other people of color and LGBTQ+ individuals are also disproportionately represented in both the homelessness and criminal legal systems. And on the next slide, digging into the data a little bit more, we see that Black adults make up 12% of the US population, but they make up 33% of the US prison population. and 43% of the adults experiencing homelessness in the United States. And LGBTQ plus individuals make up only 4.5% of the United States population, but they are 3 times more likely to be incarcerated. And one study indicated that LGBTQ plus youth experience homelessness or housing instability at over double the rate of the general population. Looking now at California specific data, Black Californians make up 6% of the state population, but 29% of the people experiencing homelessness. And Black Californians are also incarcerated at almost 7 times the rate of white people and 2 times the rate of Latinx people. And then the next slide sort of brings it home to Santa Clara County. And continuing with the example of disproportionality in the Black community, Black individuals in Santa Clara County make up 2% of the population, but they make up 12% of Santa Clara County arrests, and 19% of people experiencing homelessness in Santa Clara County identify as Black or African American. So what does this mean, right? We're talking about disproportionality and access to housing. It means that when housing providers make decisions about whether or not to house someone or offer them housing assistance, such as a subsidy, and they base that decision on the person's criminal background, then they are also likely disproportionately excluding people of color. And that is an equity and a fair housing issue. Now I'm going to pass it off to Lily.
Hi, everyone. Thanks so much for being here. It's wonderful to see all of you, or at least your names. And thank you, Viola, for kicking us off. So moving into the second reason why talk about criminal histories, probably why you're all here today. They create barriers to finding and sustaining stable housing. And as I'm sure many, if not all of you are familiar, they can do this in a lot of different ways, both direct and indirect. Right? So you're probably all familiar with things like the very direct link between, for example, access to public housing, restrictions on folks who are on the lifetime registrants on the 290 registry, or have been convicted of methamphetamine production in federally subsidized housing. But then there's also all of those indirect ways that people are impacted and that people's housing are impacted that are more based on sort of economic restrictions, things like that. And they all together create a ton of barriers that I'm sure I saw some of you in the chat chiming in saying, this is a big issue. You know, folks on the registry, things like that really experience a lot of barriers. Go ahead and advance the slide, thanks. So again, probably a lot of you are familiar with the term collateral consequences, but for those of you who are less familiar with it, collateral consequences it's a term that's used to describe the consequences that are put in place by law or regulation that are sort of sanctioned ways that people who have been in custody are impacted after they have served their sentences and are back in the community. And so that can be things, again, like the public housing authority example I gave, but also things that restrict particularly access to employment, things like business and occupational licensing access, things like voting, education, access to educational loans, things like that. And all of those things, of course, impact someone's ability to sort of live freely after they have served their sentence, like other people who have not been system impacted. But also have ultimately an impact on housing, right? You know, education increases your ability to get a high income earning job. You know, limitations on licenses, things like that can really restrict job access. And in places like Santa Clara County, most certainly California broadly, it's really hard, even if you have an education, to access jobs that, you know, will create enough income to be able to live independently. And we called the title of this slide is long-term consequences of convictions, because there are those collateral consequences, the ones that are codified, meaning they were written down in statute and regulation, but there are also long-term consequences that are not codified, right? And that's the daily discrimination, stigma, and repercussions of system involvement, and particularly time spent in custody that people play out every day. So not every time someone experiences discrimination, even if it's unlawful, they're not going to go file a lawsuit that day, particularly a successful one. So we think of it both as collateral consequences, but then as long-term consequences of conviction that impact housing, because there are ones that are not written down. There's, you know, severed family ties or frayed family ties. There's again, you know, discrimination that people experience, you know, in all kinds of daily interactions in their families, with employers, things like that. And those all really play a big role. Next slide, please. So before we move off of the long-term and collateral consequences piece, just wanted to really highlight again, sort of as Viola was just doing with the equity piece, the scope that the collateral consequences conversation really has. So every year in our country, over 600,000 people enter our national prisons, and over 10.6 million people enter our nation's jails. So if we think about every individual, described in this scenario, and this doesn't include ICE facilities and other forms of detention, and every single person who they touch, their partners, their children, their parents, their employers, their employees, the scope of who is impacted, and it's just the sheer numbers are really striking. And I'm sure many people on this call have been personally system impacted, either themselves spending time in custody or loved ones. And it is really true. I think the statistic now in California is about 1 in 5 Californians. It's really an exceptional number of people who are impacted. But if your life has not been touched by it, it can feel very removed. And that's part of what we're hoping to do in the conversation today, is kind of draw some of those links as well. The next bullet point on the slide, 74% of people held in jails have not been convicted of any crime. And this is actually sort of striking for a lot of people who haven't worked closely with the criminal legal system. Because there's sort of an assumption that if people are in jail, sure, maybe they're waiting to be sentenced or going to trial. But just the idea that the majority of people in our country's jails are actually not convicted of anything, and many of them will be cited out, charges won't be filed, or they will be found not guilty, things like that. But they're still impacted by their time in custody. Those things can happen over, whether it's 1 day or 10 days or a year, but it can all have a really significant impact. Housing can be lost, children can be lost, jobs can be lost, cars can be impounded, all kinds of stuff like that can happen, even if ultimately you walk out. And in theory should be seen, having had no different experience than someone who was never confined in the first place. And the third point, kind of similarly, is the notion that technical violations are the main reason that people who are on parole or probation, referred to as community supervision, are incarcerated. So we have a whole criminal legal system lingo 101 training that we're not doing today, but briefly, parole and probation are periods of community supervision where people have to live with certain requirements to be reporting into an officer on community supervision. And they have certain conditions that go with their parole and probation that allow them to stay out in the community. And if they violate those conditions, it often goes before a board, and there's a determination made whether the person should be sent back to custody or can remain in the community. But those violations can be for things that are not in themselves something that would constitute a crime that would typically be the reason someone would go in to custody. Potentially. So things like failing to report in a timely way, not reporting a change of address in a certain amount of time, being someplace or with someone you're not supposed to be, being around drugs or alcohol if you're not allowed to be. And those kinds of technical violations are actually the main reason people on parole and probation go into jails, not new crimes. So I include that again, just to sort of highlight the scope, and particularly because once you touch the criminal legal system, it becomes infinitely easier to continue to stay in it. That's why people talk about the cycles of incarceration. It's really, really real. And as Viola, kicked us off talking about the impact of, who is most likely to come into contact with the system in the first place is very disproportionate along multiple lines. And so again, here, this collateral consequences, even post-conviction or post-confinement impact really does stretch out very far beyond just the person for the reasons we would assume and for a much longer period of time. So I want to take a pause here. We're going to be talking a lot and throwing a lot of information at you, but before we move on, we wanted to hear from you, particularly about this last piece around barriers and who experiences them. And just to kind of get a sense, there are a lot of folks on the call, but it's always nice. We hope this is one of the first, but definitely not the last conversations about the criminal legal system and the housing and homelessness that we have. And it'd be great to get a sense of what's going on in Santa Clara. So if you can chime in the chat, or if it's easier to come off mute, you can feel free to do that now, but we'd love to hear about what barriers you see the most with your clients in your work for folks who've been impacted by the criminal legal system. If any of the ones we just listed resonate, if there are other ones that you think are really important to call out, where is it really hard to overcome barriers in the work that you're doing? Great. Yeah, jobs and employment. It's a long list, Jennifer, but you were right. Please, Alexander, feel free to hop off mic if you'd like to share something.
Yeah. Good morning, everyone. Yeah, I work program manager at Destiny Reentry. So I deal with all these barriers every single day. And housing is definitely number one. It's I call it a needle in a haystack. You know, individual comes to us, they've just been released from incarceration within the last 24 hours. And maybe the night they got released, they had to sleep on a park bench somewhere. Who knows? But they were outside. And we were trying to house them. We do our best to house them. And it's even gotten to the point where all the emergency shelters are very difficult to get into. You know, so housing plays a huge part. Long-term, permanent housing, that's almost it happens, but man.
Right. It's like the golden ticket.
Man, I tell you, you know, and so we work with individuals for a year, those who stay connected with us and within the year. But within that year's time, on a caseload of say 75 individuals, approximately, if we get 10 people permanently housed, that is like fantastic.
Right.
In a year's time.
Yeah.
So,
Thank
you
you.
know, housing is definitely the biggest. Employment, getting them into living wages, employment, that's pretty difficult, but we do get them employed. So that's not as difficult as housing.
Thank you, Alexander. We'll go ahead and take one from Victoria and one from Julian or Julian, I don't know how you say it. And then we'll move on for now, but do feel free to chime in the chat if you had other thoughts to share. Go ahead, Victoria.
Hi, I just shared one in the chat as well, but you know, I recently was doing an interview with somebody from the reentry center. And you know, something that I think doesn't always get mentioned, but it is a really big obstacle that I deal with a lot of my clients, dental. So, you know, a lot of people re-entering, they have severe dental problems, which affects their health, their well-being, their, you know, their, how they feel when they, their self-esteem, how they feel when they present themselves. And, you know, there's not very many options for them. You know, most places they just want to pull and, you know, not help restore. So I think dental is a really big issue.
Thanks for sharing that. I saw a couple of people chiming in and saying, yes, Victoria, on that. And yeah, and then of course the trauma, we have a whole other training we do about custodial trauma that I know you've participated in, but there's a big role, I feel like dental and trauma and medical access and trauma, particularly custodial trauma is huge.
Definitely. Thank you.
Yeah, thank you. And Julian, did you want to go ahead? Or
yes,
Julian?
hi. Thank you for having me. How you doing, Alex? I see you. I'm with the Good Samaritan Reentry Center, and I actually work with Alex. He's one of the other centers that does reentry. And like they were both saying, there's barriers with housing, employment, transportation, medical. We get clients that come out that don't, who are supposed to be taking medication, but leave the detention facilities without their medications. I mean, there's quite a few that we try and help. Some come out without clothing. You know, they just have what they were arrested with, and some of them been in there for months or years, and they come out with absolutely nothing. You know, and like Alex was saying, housing is one of the main barriers, because a lot of times they get out at night. There's no place to put them at. There's no shelters available. So, and transportation, how are we going to get them there? You know, depending on the time that they're being released.
Yeah, thank you so much for sharing that. And I want to just appreciate everybody in the chat. I feel like there's a huge range. People are sharing, you know, things as detailed as you know, being turned down from permanent housing, or the challenges with people being in transitional housing and that affecting their status, all the way to things like you need clothes and we don't know what time to pick you up, right? So there is just this huge range, and the barriers come into play at every step of the way, but it's a ton to be trying to navigate through and to be trying to support people in navigating through. It's again, like that kind of needle in the haystack. I think Alexander said that there's like a bunch of needles and a bunch of haystacks, and it's this, you know, someone gets out and everyone's just kind of scrambling around in that haystack. So thank you. I think that's probably helpful for folks to hear what other people are seeing. And it's helpful for us to just for future trainings and reference to see the places that people are really seeing a lot of barriers. So thanks for that. All right, so we'll move on to the third reason to talk about criminal histories, which is understanding them can help serve clients better, right? So before we go into the details on this one, we're going to go ahead and do a poll on the next slide. And this is again just sort of getting a sense of sort of where the community is on this. The poll asks about how your organization or agency uses criminal history information. Feel free to pick the one that best suits. If it's too hard and you want to chime in on the chat about why you can't just say one, that's fine. And there isn't all of the above option. But we're curious, do you use criminal history information for eligibility screening, to make housing placements, to refer people to other resources in the community, to create case management plans, something else? If you're putting other and you don't mind just dropping in the chat what you use it for, that would be really helpful. Great. And just want to, Andrea in the chat, I appreciate that last comment too. It's very much kind of how all of these things influence other things. So you just sort of get barriers stacked with more barriers. Thanks for that too. All right, we'll give it just a couple more seconds. You can share out. All right, looks good. Thank you everyone who was able to participate in the poll. And so it looks like a pretty even spread. A lot of people using criminal history information for all of the things we put above, perhaps some other things too that aren't on there. Again, feel free to drop those in the chat. And then otherwise a pretty even spread. Looks like fewer people use the information for eligibility screening, but definitely considering it when you're thinking about housing placements, referrals, and doing case management planning. So thank you for sharing that. And it actually ties into the next slide, or the next two slides, I should say, which focuses on sort of what we can and can't tell when we use criminal history information. So first with the can'ts, you know, this is sort of a nitty gritty one. And again, we have maybe another time and place to do a slightly more deep dive into this one, but it is often challenging when housing providers in particular are looking at criminal background printouts, right? That can be a rap sheet, which is record of arrests and prosecutions that you get from law enforcement. It can be a private background company, it can be court documents or something else. Sometimes it's hard to tell what you're looking at. But one thing that is true is it can be very hard to read those things and understand those things if you are not well versed in the language of criminal backgrounds, which, you know, hopefully, like ideally, we try not to be, right? Or you're a lawyer, or you have been system impacted and you could, you know, happily never see another rap sheet in your life. That would be great. But unless you're familiar with it, it can be really hard to read and to know what you're looking at. And it's really important too, right? For a couple of reasons. One, tons of inaccuracies, even on rap sheets, happen all the time. And you don't want to hold, you know, a housing, you know, a conviction for someone who had just stolen your client's identity against your client, or you want to be able to advocate for them and with property managers or landlords if that's the case. And also because, you know, it's really, really challenging to know for sure what the final, they call it the final disposition, what the final outcome of a case is. So even if you figured out how to not look at arrests and not look at the wrong kind of convictions that you shouldn't be considering, which Viola will tell you about in more detail very soon. But even if you're looking at something that's like a red flag kind of conviction for you, often those kinds of convictions have, you know, they could still be pending appeal. They could have been dismissed. They have the potential to be sealed or have some sort of record, you know, reduction remedy applied, or sometimes they could, you know, someone could have been diverted or something could have changed. So it's always really important if you do have something on there, if a client's running into a conviction that people are saying, you know, this is going to be an issue for you, to make sure that you are reaching out to resources in the community. We'll talk again about who those resources are a little bit later. To make sure that you are double, triple checking that the conviction itself is the kind that you know, someone could legally consider, that it's a valid conviction that's still, you know, it's a final disposition, and that the process is in place for people to be able to challenge any denials or anything like that based on it. The next three bullets on the slide are sort of bigger picture ones that kind of tie back into some of the stuff Viola was framing out for us in the first place. A thing that is hard, I think, for some people to kind of sit with is the idea that convictions, arrests, all that kind of information is not a sound indicator for whether clients are dangerous to themselves, other clients, or staff. And of course, a desire to keep ourselves and our colleagues and our other clients safe is incredibly important. Everyone can get on board with that desire. But where we often go astray with criminal history information is thinking that because someone has a series of arrests for some behavior that is, something you wouldn't want to see replicated in your housing project, or even convictions for it, that the story ends there. Because as we know, the people who are more likely to have those kinds of arrests and have those kinds of convictions are the same people who are most likely to experience homelessness and are people who are disenfranchised, primarily Black people, other Indigenous people, other people of color, and LGBTQI+ people, and just to call them out. And so, you have to factor that in when you're looking at this information. You may not be getting that information that would be the same for other groups of people, even though some of the underlying behaviors may be very similar. In addition, there's a whole story behind any single act, right? A little printout blurb on a rap sheet, that has 2 words, doesn't tell you the whole story. It doesn't tell you the context. It doesn't tell you, where the person was in their life in that moment. What has changed since then, the kinds of supports that help people not engage in criminalized behaviors. So it is just really important to, I think, sort of typically in our society, that's a completely fine place to go in and make assumptions, but to help educate your organizations, your peers, and other people in the community who make decisions around housing about how and why to pump the brakes and interrogate those assumptions is really important. So we name it there. And similarly, whether clients are trustworthy, there's a lawyer phrase, crimes of moral turpitude, which is basically why I went to law school, is just to say that phrase. So thank you for letting me throw it around. But the idea that if someone forges a check, they are somehow not a trustworthy person, when we know that tons and tons of criminalized activities are acts of survival, and particularly for clients that you all are working with on a daily basis, people who are hovering near homeless, experiencing homeless housing instability on a regular basis, to assume that acts that people may undertake because they are trying to eat, or they are trying to pay someone back and they owe them money, and it is very important that they get the money to the person, things like that, can then be used to sort of determine whether or not someone is trustworthy and they should be able to be in spaces by themselves or work in certain spaces or be trusted, is a really big, again, place to challenge sort of generalized assumptions that we may have. And then the last one, again, is the general concept of deservedness. I think particularly in housing, when the problem is there isn't enough housing, so we have to create structures where we're prioritizing people and we are trying to assess vulnerability, which is incredibly challenging, as you all know. Particularly with, I think, this population, it's very hard to self-report vulnerability for lots of people, but I think particularly people impacted by the criminal legal system, where there may be additional barriers to that kind of rapport building and candor when information about their criminal histories has only been used against them. It is really, really difficult, and often people impacted by the criminal legal system fall to the bottom of the sort of who deserves housing list, when in truth, everyone deserves housing. And if we start, the more we lean into those really, really problematic designations we have to make in the space of like resource scarcity, the more we adopt those ourselves and in our interactions, the more we keep people in really hard spaces where they are, being penalized really unfairly for a lifetime. So moving on to the next slide. I will go ahead now and hand it over to Byla again, who's going to tell you more about criminal history information and the kind of do's and don'ts in California around what can and can't be considered. And I do want to just mention too, if people are having thoughts or responses or like that's wrongs or that's rights, feel free to just stick any thoughts you have in the chat, because we really welcome them. Back to you, Byla.
Okay, I think maybe we need to go to the next slide, the next couple of slides. Yeah, there we go. Okay. Great. So now we are going to talk about some of the legal limitations on considering criminal histories when making decisions about providing housing and housing assistance to folks. The next slide talks about the fact that in California, there are several civil rights laws, including those listed here, which are investigate where there are complaints about those about violations of these laws are investigated by the Department of Fair Employment and Housing and also enforced by that department as well. The next slide talks about the fact that these civil rights and fair housing laws apply to all of the different types of housing listed here. I'm not going to go through all of them, but you can see that they apply to private housing, such as single family homes, multifamily housing and apartments, as well as transitional housing programs, supportive housing, residential hotels and motels and shelters. So in other words, they apply to your programs, and they also apply to the landlords and property managers who you are working with, who you're trying to get them to house your clients. All right, so this slide talks about what your role is in all of this. So since these laws will be applying to your programs if you are a provider, and the other forms of housing that your clients are trying to access, this means that you need to know about these laws to fulfill these two roles. So as a housing provider, as someone who is working for a program, such as a shelter or permanent supportive housing program, what have you, you need to make sure that you are not unlawfully excluding people from your programs, okay? And as a housing case manager or an advocate or housing navigator, you need to know about these laws so that you can help prevent discrimination against your clients as they're looking for other housing. So for our purposes today, I'm going to focus on the Fair Employment and Housing Act, or FEHA, as it relates to addressing discrimination against people based on their criminal history information. FEHA protects people from housing discrimination based on certain protected characteristics, such as race, color, national origin, religion, disability, gender, familial status, sexual orientation, and several other protected characteristics. That means that you can't discriminate against someone making a housing decision based on those characteristics. Now, having a criminal history is not a protected characteristic, but new regulations that went into effect in January 2020 made it essentially unlawful to base decisions about access to housing on criminal history information without having a legitimate justification for doing so. So this is because, as we have been talking about, using criminal history information in making housing decisions can have a disproportionate impact on people of color, as we have been discussing. And people of color are a protected group under FEHA. So what do I mean by criminal history information? Criminal history information means essentially anything that has to do with someone's interactions with the criminal legal system. So arrests, convictions, information that someone was questioned or had a conversation with law enforcement, or other types of outcomes of criminal cases besides convictions. All right, so the first key limitation that you need to be aware of regarding FEHA compliance is that you can only consider criminal convictions. That is where someone was convicted or found guilty in court. You cannot consider, yes, just a note for the people in the chat who asked the question, this does include 290s. This does include 290s, people on the sex offense registry, absolutely. And that's why we're giving this training, because there's a lot of misinformation out there. And Lily's going to talk about that more in a moment. Yeah, she's going to really dig in. So back to what I was saying, you can only consider convictions. You and landlords and property managers cannot consider other types of criminal history information, such as arrests, any information about times that someone was questioned or brought in, to the police department or whatever for questioning, infractions for things like speeding, when a criminal case results in an outcome that doesn't involve a conviction. So for example, if a case was dismissed after someone participated in a drug treatment program or something like that, Also, convictions that have been sealed or expunged cannot be considered, and the outcome of juvenile court proceedings. And the reason for this is, as Lily said, people are subject to arrest and questioning and are charged with crimes all the time. But until they are convicted, they're presumed innocent. And even after conviction, there are certain situations in which our society has determined that people should have their records sealed, or that certain convictions should be expunged so that they don't have to deal with some of those collateral consequences that we've been talking about. So again, that's the first important thing, is no criminal convictions. Okay, or sorry, only criminal convictions rather. The next slide talks about if you do consider convictions, right? If you are going through some sort of criminal background process, or landlords are doing that, they can only consider convictions that are directly related to housing. Okay, so in identifying whether a conviction is directly related to housing, you want to consider a few different factors. The nature of the crime, first of all. Was it violent? Did it involve some sort of massive property damage? The severity of the crime, how serious or dangerous was it? And how long it has been since the crime occurred. And the reason for that is that people may have been convicted for crimes that have absolutely nothing to do with how they will act as tenants and how responsible they will be in a unit, especially if the conviction is particularly old. So for example, someone who was arrested for possessing cocaine, 10 years ago is possibly differently situated than someone who was released last week after serving, many years for residential arson or something along those lines. So you're really thinking about, does it have to do with safety and housing? Okay, so the next slide talks about the fact that FEHA also prohibits the use of blanket bans for people with certain conditions. So for example, a provider can't say, we don't accept anyone who has a felony, or we don't accept criminals, or we don't take anyone with an assault conviction. You can't just say, we will not accept anyone who has a certain class of convictions, right? And that's because when you're determining whether or not to provide housing to someone, you have to do that individualized sort of assessment of, is this particular conviction related to my legitimate safety concerns? And is my decision to exclude this person actually keeping my housing safe, making my housing safe, right? Is it actually going to achieve that end? So that's the reason why you cannot have blanket bans. Okay. And then this slide talks about some other considerations that housing providers should think about to help ensure that they're compliant with FEHA. So any criminal background check policies should be in writing, and policies should include that the housing provider will give applicants a copy of whatever criminal history document they were reviewing. So for example, if they pulled someone's rap sheet, then they should provide the person with a copy of that rap sheet. And the reason for that is that, as Lily discussed, rap sheets can be rife with errors. And we want to give people the opportunity to correct any errors on the rap sheet, to say, okay, this is not correct, or this was appealed, or this was dismissed, or that's not me, or whatever. And then you also want to tell them what your reasoning was, so that they can then try to get what we call mitigating information. And I'll talk about what that is in a second. But essentially, housing providers need to consider all mitigating information that's provided. And if you are a housing case manager helping someone get into other housing, you're going to want to help your clients obtain mitigating information. So the next slide talks about, what is this mitigating information? Mitigating information is information that explains that an applicant is not likely to pose a demonstrable risk to the health and safety of others or the property, or that they're not going to pose a risk to any other legitimate goal that a landlord has, that they're saying they don't want to accept the person, because they're going to prevent them from achieving that goal. So examples of mitigating information could be the age when the criminal conduct occurred, right? So, if someone was 18 and now they're 70, that shows that, a lot of time has passed, right? if the conviction was related to a disability. So for example, is someone on the 290 registry because they exposed themselves during a mental health crisis, and now they're in treatment, or now they're receiving support that they need to maintain their mental health, sort of explaining what happened, why it happened, and why they don't pose a threat anymore, or why they never posed a threat to this particular program, or this landlord, or this housing program. Other potential mitigating information can be that the person was a survivor of domestic violence when the conviction occurred, or perhaps they were a survivor of human trafficking, and that related in some way to the conviction. So that's basically what we're trying to get at, is explaining, giving the person a chance to say, hey, you don't have to worry about me in this housing program. Okay, so let's see. Before we move on, we wanted to pause to see if there are questions, concerns, comments. We know that this is, big topic. So I'm just going to take a moment to have a look at the chat to see if there are questions, comments. Okay, so someone asked, what about theft? So essentially, like I said, there's no conviction, no program, and no landlord can say, I won't take someone who was convicted of X, Y, and Z, including theft, right? What needs to happen is, if you're conducting a criminal background check, or a landlord is, and they see that you have a conviction for theft, what they need to do is really think about, okay, how long ago was the theft? What, if anything, do they know about, the underlying conduct? And is theft really something that we should be excluding someone from housing for? Is it related to a safety concern? What is this about? And will excluding this person really achieve that goal that I have of safety, or whatever the particular goal is? So it's really doing that individualized assessment, and then giving the person the opportunity to say, to tell them, hey, I'm thinking that I can't house you because you have this conviction for theft. And then giving them an opportunity to respond and say, I was high on meth at the time, and that was 15 years ago, and I've since completed a drug treatment program. Or, I was trying to get formula for my baby, whatever the situation is, but giving that person a chance to tell their story and explain what's happened. So hopefully that example is a little bit illustrative, and I answered the question. Okay, who would we go to if housing placements are not following this rule? So what you need to do is make a report to the Department of Fair Employment and Housing. They're responsible for investigating all violations, and then dealing with whatever enforcement they would do. Sometimes they will, go to court on behalf of somebody, or, take some other kind of action, but it's the Department of Fair Employment and Housing, and we can put a link to their website in a moment. Yeah, so again, with Lisa's question, which is what happens if a property manager or agency does not take the steps and consideration, someone can make a complaint. They can make a complaint, and then the Department of Fair Employment and Housing can then take action, and they can take a wide range of actions up into bringing someone to court. Okay, any other questions? Feel free also to come off of mute. And I see another one that says, does this apply to the statement must be able to pass a background check? So it's okay for people to say that, we conduct background checks, and it's okay for people to advertise that. I don't know about the statement must be able to pass a background check. I don't see anything inherently problematic about that, assuming that the background check is appropriate and takes all the steps necessary under FEHA to, make sure that that the background check policies are actually justified, right? And that they're only making decisions about excluding people based on a housing related safety concern, essentially.
And I would just chime in on that one too, and say, I think, that phrasing, there's nothing that explains what it means to pass a background check. A background check isn't like a pass fail test, right? So if they mean if anything shows up, then I would say that that wouldn't be an okay policy to have, but it's not saying what they will do with it. And again, as Violet kind of spelled out a little bit, there's a process that you have to have and kind of a logic that you have to spell out for people when you're considering things about what you're doing. And the truth is, a lot of this stuff, the questions about how far, and we've had a couple questions about look back periods, meaning how far back you can look. A lot of this depends on the housing, certain like public housing authorities or certain projects or programs will have policies on their look back periods, but a lot of this has to do with understanding what the policies are of the property manager, landlord, entity that someone's seeking housing from, and making sure that those are in compliance or requesting that they are. And then also, having folks kind of articulate what they're thinking and their thought process is. And that's the FEHA piece, is it really just, it doesn't say you can't exclude people. It just requires you to have to justify and explain and be transparent about how you're making that decision. So again, we can do a longer training on this for sure, because there's so many good questions, but this is just an overview of this. So again, feel free always to reach out with questions, follow up afterwards, but it's tricky stuff. And there's a lot of subjectivity, which is part of the reason that they made these changes to the law that are recent too. So a lot of this is, people are just doing what they've always been doing, because in 2020, people are a little busy and we're not updating their policies or checking to see if FEHA had any changes or had ever heard of FEHA. So some of this is an education piece, and that's kind of what we're hoping to help provide you all today, is the tools to have those conversations a little more effectively.
Yeah, so I think just really quickly, I found the website that has information about the complaint process if you're curious about that a little bit more. Alexander, I see that you have your hand raised. I think we are running a little bit behind schedule. Do you mind holding on to that for just the time being, and then we'll get back to you, or you can put it in the chat and we can respond maybe via email or personally. Is that okay with you? Okay, great. All right, we will come back to you. All right, I'm going to hand it off to Lily now.
Lily, who had six screens pulled up, none of them the ones you needed. Sorry about that. Okay, so we're going to shift now into talking a little bit about working with folks on the registry. And I just want to flag before we go into this that, the focus of this presentation here today is to talk about the challenges that people experience trying to help support clients who have these extra barriers, both collateral consequences that are absolutely written into the law, and then all of those long-term consequences of conviction that are the daily things that maybe aren't written into the law, but certainly produce barriers. So that's the focus of how to support these clients. I will tell you right now that we do not have any silver bullets, like the one thing, here's that one resource that we've been holding out on you about. So I just want to flag that to have expectations set, but we hope we have some tools that will be helpful. And I also just want to flag that talking about sexual harm is really, really hard. It's a very scary and intimate space. It's a huge problem and a huge concern. And again, going back to just validating the desire for people to keep themselves and their clients and their loved ones and their staff safe. That's a really big deal. And so we don't mean to diminish any harm that has been and can be caused by acts of sexual violence, but we do want to be realistic about sort of understanding the registry, what works and what doesn't work about it. Do a little bit of myth busting about the registry and who's on it, because it may not be familiar for people who haven't been impacted by the registry themselves or a close person to them. And then again, move into some sort of tips before we finish out the training with some of the sort of links to resources and things that we've been referencing. So I'll go ahead and get started. So the first slide is doing a little bit of kind of basic level setting of what we do and don't know about the registry. So some of you may know this like the back of your hand, but it may be new for some of you. One is that just simply that California requires people convicted of any one of, it's actually over 100 crimes, to register their whereabouts with local law enforcement periodically. And I have some examples of the types of convictions that frequently require registration, just to give you a sense of the range of the criminalized acts that people that can land people on the registry. So things like public nakedness, selling sculptures or portraits of paintings depicting content considered to be child pornography, sexting, which is a huge issue, particularly for youth on the registry, things like rape, which are more kind of immediately what come to mind for a lot of folks, urination in public, child trafficking. So, I picked these out just because they really, I think, illustrate the huge range. And often people have very different responses when they think of like, oh, teenagers sexting versus, oh, child trafficking. There are very different associations I think a lot of people make with those concepts. And it's sometimes surprising for people to learn that until this year, California has put anyone on the registry for life. If they land on the registry, you're on the registry for life, regardless of, the type of conviction. In that way. The second point on here is that people on the registry reflect a full spectrum of economic statuses, racial and ethnic demographics, sexual orientations, gender identities. And again, we're convicted of a really wide range of criminalized acts. So just a huge scope. Yes, Jenny, it's a lot. And the scope, again, is then sort of compounded by the fact that unlike most people who've been convicted of a crime, even others very serious crimes, there's a unique quality to being on the registry, which is that you are required to register and appear on the Megan's Law website in California. And that website posts many registrants' names, addresses, conviction history, and often their appearance. And so that's very different. If I have been convicted of, theft or something like that, there isn't a database where people can go and identify me where I live. And that's a very different, and there's lots of, public safety rationale that went into making those decisions, which we'll talk about in a little bit. But just again, to highlight the unique stigma and the unique collateral consequences that attach to people on the registry, even more so than people who have been incarcerated for other reasons. And the last one feels probably like a no-brainer, but being on the registry significantly restricts certain freedoms otherwise available to non-registrants. So for example, under state law, I gave the example earlier of the Public Housing Authority exclusion, which I suspect you're all familiar with, but under state law, two people on the registry cannot live together unless they're related by blood, marriage, or adoption. And at first blush, you can kind of see the logic on this one, what people are going for. But then, and I'm thinking some of you have probably run into this, if you think about how limited, for example, housing opportunities are for people on the registry and how there may only be a handful of landlords or property managers that you or your organization know about, and people need shared housing, it can start making it even harder to place people or to help people find access to housing or to allow for any kind of housing choice for people on the registry when they have this additional collateral consequence. It's statutorily required that they cannot do that. And so just again, how there's this scope and the kind of practical impacts of it that may seem like it makes sense from a public safety. You can see how they ended up there, but that the reality of what it looks like on the other side is either not on people's radars or not thinking about it or caring about it when they write the laws, but then they are also, how it plays out in practice is really different. Oh, yes. Thank you, Byla. That's a very important clarification. You do not have to have 100 convictions to be on the registry at all. Okay, so moving on to the next slide, registry facts and assumptions. This is our little mini history whirlwind. So feel free to sit back and sip your coffee for this one. One fact that we wanted to start with has to do with who is on the registry. So many people on California's registry are there because of discriminatory laws. So California's registry was actually the first one in the country. It was created in the 1940s. So prior to this year, California was also just one of 4 states in the country that had an automatic lifetime registry. So the others were South Carolina, Alabama, and Florida. And because the registry was created in the 40s, there are a lot of sort of attitudes about sexual conduct that reflect, the 1940s era, as opposed to a more modern, updated reflection, at least for many people. And that included, among many things, pretty open discrimination against same-sex sexual conduct. So some of those laws have been changed in the 80s and the 90s in California to help, take people off or stop sending people to the registry based on those kinds of discriminatory laws. But there was one that was passed in 2020 to address the disproportionate impact of LGBTQI+ youth on the registry. And I won't go into all the details. If you want to look it up, please feel free. It's a really interesting history to the passage of this law. It's SB 145. And it had a ton of support from law enforcement, advocates, all kinds of reasons to try to address that discriminatory impact. But again, it just passed in 2020. So there are lots of people who are still on the registry because of that discriminatory law. And that has been something that the historical legacy, if you have older people on the registry, things like that have really played a role in who is on the registry and why. The second fact is in 2017, California spent $140 million a year to register youth, just youth, yet designated in the state budget only $46,000 for victim services and prevention. So this is just a little snapshot from a specific year. And there are, there's lots more money to be pulled in for both of these things in different spaces, but it just illustrates that there is also this question of, our desire to put people on the registry is very resource intensive, but the actual addressing the harm that is caused by sexual violence and sexual harm doesn't get as much attention. And that's just sort of an important factor, I think, when we're thinking about sort of sane responses to crime and violence, that sort of smart on crime approach, to keep that in mind, just where resources are going. And the third fact that I wanted to share, and I do see the chat is very busy, so we will visit these questions again. Thank you, keep them coming, and we'll be tracking them as we go. The third fact is that California's new tiering law, which I will tell you more about in a few minutes, what that actually means and how it works a little bit. But just to let you know here that it's not automatic for those on the registry. So as it was initially drafted, 90% of people on the registry would have qualified for retiering, this law that was just passed this year. And as it was ultimately passed, still 60% of people on the registry are eligible for retiering, but it's not automatic. And it's a very new process. People are trying to figure out how to do it, who can do it. Courts are trying to figure it out. DAs and PDs are trying to figure it out. I know we have some folks from the Public Defender's Office on here, so feel free to chime in. We have some resources connecting people to you that we'll share later. But for a lot of people, 60% of people on the registry could potentially be off the registry or certainly off of the lifetime registry. And they need help most of the time to be able to get that retiering. And there's a process that we'll talk about in a few minutes. Yeah, Conrad, I see you. Thank you for keep them coming. But that's just really good for you all to know that there may be hope for a lot of the clients you're working with on the registry, and something to do about it, but it does require some doing. So we'll go ahead and go to the next slide. So moving now from the facts to some assumptions. The first one, sex offense registries prevent reoffending. This is a pretty challenging pill to swallow, I think, for a lot of people. But research has shown, including Department of Justice research has shown that registration systems do not reduce recidivism or prevent new sex crimes. And there are a whole bunch of reasons to go into that, but just calling out a couple of the major reasons. About 95% of solved sex crimes are committed by individuals who have not previously been identified as sexual offenders, and so therefore were not registered. And also about 93% of sexual offenses committed against children are committed against the child by people who are known to the child, not by strangers. And there's a lot of kind of, I think, fear. And again, going back to those like real desire for safety and to protect those that we love, our staff, our children, those things like that. But the truth is most sexual violence isn't reported, and that which is, it's usually not somebody who's on a registry because they live down the block and everyone knows where they live, but actually people within family systems, trusted people, things like that. And that's devastating. The truth, the idea that there isn't as much to do about it from this vantage point is really challenging, because this is putting people on registries since 1940 is where we've been going. But the evidence doesn't actually support that it does much in that space. So the second assumption is that registries are necessary to help law enforcement and the public track people who present the greatest risk to the community. And I've already sort of addressed a little bit of the underpinnings of why this is a faulty assumption. But I will just add to this that, a real challenge that a lot of, I don't know if there are folks on the call from probation or law enforcement or parole, but a big challenge is that there's so many people on the registry that until this retiering law passed, that we're all having to sort of be treated to some extent the same. That's a huge resource pull. And so if you're having to have everybody be registered and tracked and, doing all the same stuff at the same time, you don't have as much ability as law enforcement, as community supervision, as community resources providers, even as housing case managers, to really focus on supporting the people who most need that support, the people who are much higher risk. They have, long-standing behavioral health, mental health challenges, things like that, where they really need that specific focused resources and support. And instead it makes it a much more sort of broadly spread out resource strain. And again, because they haven't been shown to be effective, it is sort of a questionable approach. And then the third assumption we wanted to address is, not unrelated, but restrictions on housing for people in the registry improves public safety. That is, of course, at the heart of the argument for registry, why they were created. But it in fact doesn't do what it's designed to do for the most part. So restricting housing options for people who tend to have co-occurring disorders, difficulty getting employment, difficulty getting housing even without these restrictions leads to greater instability. Nobody really who sits down with it and says, having this person not be able to get into housing, but rather have them, sleeping under bridges or bumping around from hotel to hotel every 3 days with the little bit of money they get from probation or parole. No one's going to say like, that's the way to get someone stable and have them be in a space where they will, not start drinking or not engage in behaviors that got them into trouble in the first place, not experience severe stress, that'll help them be able to take care of their mental health needs. That just doesn't make sense. And so the idea of what true public safety looks like can really be challenging when we think about sort of how we've relied on the registries historically versus what we know to be true about what helps people, stay healthy, stay stable, and avoid criminalized conduct. So that's a lot. We'll go ahead and do just a couple more just on this topic, including a couple current registry considerations. So this came up in the chat already, but just to re-emphasize, FIHA, which Bila was just describing, applies to all criminal history information, regardless of the nature of the alleged crime or the conviction. So that means anyone, even if you have a conviction for an offense that would require you to register on the 290 registry, it still must meet FIHA requirements. And it's important, I've put this in here. This is kind of, if you want to nerd out about it with me, you'll have my email at the end, but it's important to think about this, particularly in the context of the interim rule language that many providers in California still rely on that has, I quoted it here, this is from the fair housing provision of the interim rule. If the housing has in residence at least one family with a child under the age of 18, the housing may exclude registered sex offenders and persons with a criminal record that includes a violent crime from the project, so long as the child resides in the housing. And this is, yes, thanks, Bila. And we have a citation to this too, if you want to look at it later. And so this, this is sort of a challenging thing. I've definitely seen in organizations in the communities, policies and procedures, this language cited. But now that you've heard the kind of FIHA background, some of this may be standing out to you, issue spotting wise, right? So first, there's the idea that if there's a child under the age of 18, someone on the registry, not everyone by a long shot on the registry is there because they had inappropriate sexual conduct or caused sexual harm to a child. So the link there between those two things logically, though very much historically sanctioned by our society, the logic there doesn't quite make sense. It's also very vague. Persons with a criminal record that includes a violent crime. What constitutes a violent crime? What constitutes a violent crime? When was it? Is it 40 years ago? Is it 20 years ago? What was happening? So again, the interim rule questions, I think this particular language is also sort of interesting to read with some of the more recent HUD guidance around fair housing and around making sure housing is not discriminating against people with criminal histories. So just an important place to think about yourselves organizationally, to continue to have a conversation as a community around this topic. And again, we're happy at Homebase to have more in-depth conversations about this as well. And so the last slide on the current registry considerations has to do with this new law, this retiering law that I keep mentioning. Effective January 1st of this year, so almost a year old, California sex offense registration scheme is now tier-based. So instead of a one-size-fits-all, everyone's on for life, there's a tier 1, tier 2, and the tier 3 is the lifetime registry. And if you're on the tier 3 lifetime registry, you cannot petition to get off of it. But for tier 1 folks, there's a 10-year it's considered a low-level offense, so you must be on for 10 years. But after that, you can petition, go through this process to be retiered and potentially removed. For that one to be potentially removed. Retiering is the process of having your information assessed to be placed on a tier, because before there wasn't a tier. Petitioning for removal is what you would do once your limit, 10 years, 20 years, for example, was up. You would go through the process of doing that. So tier 2 is 20 years. And then again, as I mentioned, the third tier is lifetime. So one of the things I just want to flag with the retiering, one will let you know sort of who's doing it in your community, how to connect. It's a lot to ask a housing provider or an individual on their own to navigate, particularly because it's new. So there's a lot of kinks to be worked out, the whole process. DA's offices, law enforcement, PD's offices are all kind of figuring out like how to best streamline this. And it's hard because every county is different and how they operate is different. But one thing to flag is that, for example, public housing authorities, the HUD requirement that people who are lifetime registrants should be banned from public housing, that changes if there's a tiered registry and someone is on for 20 years. They're no longer a lifetime registrant, and so that ban does not apply to them on its face. So really important, if you all haven't, as an organization or as an agency, gotten together to think about how this changes things and why this changes things and how to make sure folks you're working with on the registry have this information, really, really encourage you to do that because it can have really life-changing, both in the housing space, but as you know, in all of the spaces, impacts. All right, so we are gonna wrap up with our final section of some considerations and additional tips. And then we'll try to have a little bit of time at the end to revisit some of these questions that we didn't get to in the chat. And again, if we missed them, we're happy to follow up via email. So I'll go ahead and turn it back over to Viola.
Okay, so what can you do to address these barriers and increase housing access for people impacted by the criminal legal system? All right, so the next slide is just going to remind us that you want to make sure that you understand FEHA restrictions on how criminal history can and can't be used to make housing decisions. So again, no blanket bans, only convictions can be considered, and those convictions have to be directly related to housing. Also, you want to rethink document readiness. So a lot of times when we think about document readiness, we think about things like making sure that someone has their identification or their pay stubs or whatever other documentation a landlord might want to see when they're applying for housing. But you also might want to think about getting mitigation documentation. So the documentation that helps explain someone's conviction, sort of those things that we were talking about, the nature of the offense, how long ago it was, the circumstance surrounding the conviction. What, if anything, has happened since they were convicted? Have they been pursuing their education? Have they been involved with their community in any way? Have they completed any services? That kind of thing. Also possibly thinking about doing in-reach at jails to try to start working with people on getting documentation early. So, you know, if you think if your program is going to be taking people directly from jails going into the jails before release, to try to talk to people about what they might need, and also to get documentation from the people who are working with them in the jail, because that'll be a lot easier to do before they're released. Also working with your client's attorneys to try to help understand their situation and obtain accurate documents. Again, like we've been talking about, a lot of rap sheets and other criminal history, like background check documents, have inaccurate information, and an attorney can help you sort of sort out what's real and what's not real. Okay. So you also want to work with your client to reduce the barriers that are specific to their criminal legal system involvement by developing a specific plan to sort of identify what those particular barriers are for them, to know about the range of housing programs and resources available to your client, and also by working closely with any community partners that they may be connected to, such as their parole officers, other service providers, other client support systems, who might be able to provide that mitigating information or supports. Also, if you're helping your client get into housing, helping them think about how to reframe their story for landlords and property managers, not hiding, their past, or withholding information or giving false information, but rather highlighting their strengths, and helping them talk about, what makes them a good tenant and why they should, the landlord should consider housing them. Also referring your clients to legal services to help with expungement, or to help with some of the 290 retiering stuff that Lily was talking about. And we have contact information here on this slide for the Santa Clara County Public Defender's Expungement Unit. So you can get in contact with them to see if they can assist your clients with that. Okay, and then also, another really big important part of, what you're learning about today is you're learning about these laws so that you can help educate landlords, right? Landlords might not know that they're violating FIHA, but it's, incumbent upon us to, spread the knowledge and, help advocate for people both, within your programs, if you feel that people are being excluded unfairly from your programs and you can make a difference there, or perhaps, when you're working out, in the field and trying to help people get into housing on the private market. I will hand it back to Lily then.
Thanks. Sorry, I'm trying to respond to as many things in chat as I can. So apologies, I was mid-type, but let me finish this out first. So back to the tips for reducing 290 related barriers. So landlord outreach and incentives. I know this is a very live conversation and is very useful to be able to do this as much as possible for all clients, but particularly around folks on the registry. There are individual landlords. I see in Santa Clara, there are people who chime in on the listserv and stuff like that when there are requests that go out. So there are people and programs in the community doing that. I know there's a question I was just trying to get to about resources. If you are a housing program that specifically works with people on the registry, or if you know of landlords, or if you know of property managers, please feel free to plop that on the chat right now. Help each other out. It's sometimes hard to let go of a really good resource if you know it's scarce, but the only way to make sure that people are getting this information is by sharing it. So really do encourage you to use landlord outreach and incentives for this population. I have heard, just in different communities where we do this work, that sometimes making that one connection with one property management company, something like that, and then really trying to figure out ways to support them in spreading the word because they have business associations and word of mouth, making sure those clients are super well supported and being amazing tenants. And you can really start shifting things, even though it's not as great as big systemic shifts. Those one-on-one personal connections, incentives, and encouragement can be really, really meaningful. Another tip that we wanted to share here, it's a little bit dicey one, so I will give you a big old caveat, is to use the 290 registry as a resource. In a sense, we've been told that sometimes people go and they look at the Megan's Law website to see where properties are, where the landlord might be open to housing people because there are people housed there. And if you don't know of landlords or property managers who are open to those, who are open to housing people on the registry, that can be a great way to tap into some of those. And then again, to try to help extend the information. Some of the information we shared hopefully today will be of use to kind of doing that myth busting and try to help, sorry, that's my dog, educate others about why this is a population who, should be welcomed into housing and why it really serves public safety to do so. But really the big caveat is to remember not to encourage clients who are registrants themselves to access Megan's Law website, because that can be, they're prohibited from doing so. And you don't want to make a suggestion that will land somebody back in prison, for example. That's never a good look. And then the last one is leveraging community resources. So there are not, as I'm sure you've noticed, a ton of resources out there for people on the registry. A lot of that has to do with the stigma, right? Of, if you're saying like, hey, we're the folks on the registry housing project, come on by. That's a scary thing to do. And so hopefully that is starting to shift. We did put a link on these slides, which will be circulated later. Friends Outside, based in Los Angeles, has a toolkit that includes a section for people on the registry that has information on supportive organizations and other supportive groups for people to connect to. As a lot of you know, having really strong community supports when you're coming back from incarcerated settings to the community are essential. And for folks on the registry, that support, family support, things like that can be extra frayed or non-existent. So that's just one example, but there are other groups out there who do this, and a lot of them are listed inside of that toolkit. And there's also a section for tools and resources for people working with people on the registry. So encourage you to check that out. Next slide, please. Okay, and then other ways to reduce barriers for folks on the registry. So help with post-housing denial advocacy. We've already mentioned public housing authorities, where if someone is no longer a lifetime registrant, they shouldn't be, they don't have the HUD rule to advocate. to use as a bar for someone who's a 10-year registrant or even a 20-year registrant, but they may not know that. Again, this is all new. So really engaging in the sort of education piece of this is going to have, big ripple effects throughout the community as we try to destigmatize and educate people about the realities of the restrictions and also the realities of who's being impacted. Same with private landlords, as I just mentioned. Helping clients request tiering information and confirming its accuracy. There was a question in chat about this. In theory, every person on the registry should have received a letter with their tier information, and that is not happening in lots of communities. I'm not sure actually if anyone knows if people are getting those letters in Santa Clara. Feel free to drop it in the chat. But also if your client is housing unstable or homeless, real hard to make sure that an important letter like that is reaching them. So there are ways to request that information to confirm its accuracy, and also to then help eligible clients, once their tiering has been established, petition to terminate or to be retiered. So I dropped the info. I know someone from the public defender's office chimed in with their contact information. Thank you so much for that. And they do have really useful, the Santa Clara Public Defender's Office has useful information about this process on their website that you can check out. And you can also call their post-conviction unit. There's a number there, or a 290 registration at pdo.sccgov.org email that you can reach out to if you have questions. There also are legal service organizations in the community who are trying to build capacity to help clients with this. So definitely something worth connecting with other legal aid organizations in the community, checking in with a Santa Clara Public Defender. Again, this is new, so people are just kind of getting their sea legs under them on the best ways to move forward and help people. But particularly for clients who, if you have a sense of the nature of their crime, or if they did get that retiering letter, or you can get it and it seems like they may be eligible for retiering, and some of that you can check online, definitely really worth checking out. Okay, next slide. This is our reference slide. I don't have to tell you anything about it, but if you're curious where we got some of this stuff from, there's some clickable links in there for you. Next slide, please. All right, I think we made it to the questions. So just take one moment, because I suspect people will be sort of drifting off. We do have a link to sign up for the Criminal Legal System Initiative at Homebase's mailing list. Please feel free to reach out with questions, follow up, or other questions. And we also have a survey link about this training. This is something we're refining and we're doing in lots of communities. So if you can take a few minutes to fill that out, we'd be incredibly grateful. It's short, we promise. So you can even do it now. So thank you for that. And with that, we can go ahead and revisit some of the questions that have been coming in chat, or people can feel free to raise their hands and hop off if you have questions that way as well. I can dip back into our chat questions. Does anyone have, I'm just trying to scan. Does anyone have a question right now that's top of mind? As I scan back. Okay, I will skim back up. So I think there are some questions. Oh, there's Julian. Hi, you want to hop off? You're welcome.
Yeah, hi. Okay, I noticed that you said there's, was it the toolkit? Was that consist of Friends Outside, or?
Yeah, it's Friends Outside published it, and it has different sections for different things. You can click the link when the slides go out, or you can definitely Google it right now too. But it's got some just resources. There's an organization called AXAL, the, oh my gosh, Association for Constitutional Sex Offense Laws, something like that. But there are some support groups, some sort of activism related groups.
I've actually done some of their seminars with Friends Outside. And they're basically based in the Los Angeles area. I tried to reach out to them to see if there's anything available on here in Santa County, and was unable to get anything. If there's anything out there that is available, I would like to have access to it if possible.
Sure. Yeah, I think that's right. I think their resources for like local organizations and programs are very Los Angeles specific. The toolkit is broader stuff. So it's more about like nationwide organizations that people can tap into. For those local resources, and I know there were people who were asking before, I don't know off the top of my head of any one organization or entity that has those. If you are someone who is that entity or organization, please put it in the chat. Let us know how people can get in touch with you or access your resources. And there also are some Bay Area organizations that probably have a good sense of those things, organizations like Root and Rebound, who do kind of resource guides and stuff like that on a regular basis. I would suggest checking them out. But a lot of this is kind of a community-wide effort that has to happen. If you don't have a Friends Outside chapter where you are, figuring out who knows about really good resources, who's doing a great job of addressing these needs, and trying to share that information to build that kind of resource in the Santa Clara community. Joan, I'm seeing your question right there. I don't know the answer to that. If anyone on the line knows what the training for housing authorities or the situation for housing authority is in Santa Clara, please let us know. My sense is, it's very community by community. Again, we do this work across California. My sense is that, everyone's playing catch up as best they can. I think it has to do, there's a lot of discretion that housing authorities have to set things like look back periods, things like that. But they are absolutely all have to, follow FEHA. So there is that piece there. And I think there have been a lot of questions, and I think everyone's sort of looking to HUD to see what HUD's guidance on these kinds of changes, will look like. Because again, whether it's on individual public housing authority radars that, people can be retiered and they are no longer lifetime registrants, is kind of hard to tell. So again, I turn it back to you all if anyone knows what the status of that is in the community. We may be able to ask to Nicole. I don't know if that's, something that we have a line on that we could try to, follow up on, but it's a really good question. And again, for right now, it's probably individual education that's going to do the trick, but hopefully as the law kind of gets more settled, there will be shifts that are happening and education that will be happening.
Thank you.
Of course. I'm just taking a look again. Please feel free to raise your hand. I know there were some questions about look back periods, and I had a kind of unsatisfying answer, which is it depends and it depends. It depends on, mostly it depends on the entity. So again, no matter what, they have to follow the FEHA, rules for process. But places often a lot of public housing authorities or other programs will have, less so with landlords a lot of the time, will have a limit. And I think public housing authorities are required to have that kind of limit where they decide, and it's a community process to determine when those things have shifted. So it depends is the short answer. And then you definitely feel free to reach out if you have questions about specific places. And I really encourage you to reach out to the location, the public housing authority. Their information should be publicly available to look and see what their look back period is. But for private housing providers, definitely asking that question, I think, is a really good place to start, and even having a conversation about it. Jenny, I wish I had a short answer for that, and I don't. It's sort of outside the scope of our training here today, but again, just encouraging people who have good leads on resources and jobs, things like that for people. This was more of a big picture whys and hows and some of the big barrier removing stuff you can do, but the actual specifics of this is a great housing project that works specifically with people on the registry. We don't have that with us today, but really do reach out. I don't know if Juan is still on the line, but to the Reentry Resource Center and other kind of big players in the community who do reentry services. If you're still on the line, please do feel free to chime in if you've got good thoughts for other people who are looking for that information in the community.
Yeah, for jobs and resources, I know that Job Train quite often has many job postings and availability for 290s. So just keep that in mind that there are out there.
That's really helpful. Thank you.
I also want to mention something. I just put it in the chat. I didn't write, it's in San Jose. There's an employment, it's Restaurant Depot. They forklift certified, it's a union job. They do absolutely no background, but you have to be able to pass the drug screen.
Victoria, we can always count on you. Thank you so much. Yeah, it's this little community sharing and education stuff that can really make a really big difference. So thank you for anyone who has those kinds of leads, because I'm sure everyone knows what it feels like to be looking desperately for them. There we go. Alexander, thank you so much. Great. Keep them coming. All right, well, I think we're just right about at time. I'll go through the chat later and see if there's anything that we super didn't address, but do feel free to, you'll have my information and Vila's information. You'll have Nicole's information from the announcement and the criminal legal system initiatives email too. So feel free to follow up with any additional questions or comments. Again, if you can take a couple minutes to do the survey, we would love to make this training as helpful as possible. So really benefit a lot from your thoughts, and thank you all for showing up. This was a really great group, and thank you for all that you shared with us here. Hopefully it was beneficial. At least can't solve the problem here today on this hour-and-a-half training, but at least starting conversations and trying to call out some tools and resources and identify areas where we really need to, as a community, think and work more closely on some of these overlapping issues. So thank you again. Thanks, Nicole, as always, and everyone have a great rest of your day.